Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi taala wabarakatuh. My name is Muhammad Zahid Iskandar bin Muhammad Azli. Metric number 1212758. I am from KMD 1. Today, I will present about a case review titled Muhammad alias bin Ibrahim v RHB Bank Berhad and Ana. So we can see here the table of content consists of 5 sections, which is introduction, fact of the case, legal issue, enrollment process, and lastly application of law. Firstly, introduction. The first defendant asset, right, and obligation regarding Islamic banking business were transferred from him to the second defendant on March 8, 2005 in Kuala Lumpur by way of severing ties with the first defendant. Next, we will look at the fact of the case. Firstly, on a plot of land, the plaintiff alias wanted to build a bungalow home. When there was a misunderstanding between the plaintiff and defendant of the facilities, the bungalow house was deemed unsuitable for habitation. Next, the plaintiff brought the lawsuit to have the facility agreement declared null and invalid. Other than that, although unsuccessfully, the defendant sought to have the plaintiff claim dismissed. And lastly, according to section 56 and 57 of the Central Bank of Malaysia Act 2009, some Sharia concern had come up during the application for striking out and require a referral to the SAC. Besides that, I will present the court must decide the following question based on the case fact. Firstly, whether the Act section 56 and 57, often known as the Challenger provision, conflict with Federal Constitutional Article 121(1). 2. Whether the Sharia Advisory Council or SAC was abusing its authority by deciding legal matter that was outside the purview of the court. Third, whether the requiring court parties who were denied the opportunity to be heard to abide by the SAC's judgment. Next, whether the contested term affected the transaction retroactively. Next, whether the federal court should be consulted on matter involving the legislative authority of parliament and the judicial authority of the Federation over the Sharia Advisory Council. And lastly, whether the two terms differ from one another. Next, we will look at the discussion that have been made. Firstly, case involving Islamic banking may be heard in civil court Federal List 1. Although it has been ruled in several prior cases, the practice of civil court submitting inquiries about Islamic law to Islamic authorities is not new. Zulkifli Abdullah vs Affin Bank Berhad Bank Kerjasama Rakyat v MC Corporate. The main objective of the SAC was to establish a specialized committee in Islamic banking and finance. not to carry out judicial or quasi-judicial function, and not as an attempt by the government to usurp the judicial authority normally held by the court. Lastly, application of law. In Section 56 Central Bank of Malaysia Act 2009, firstly, if a Sharia-related question arises in a procedure involving Islamic financial operation before a court or arbitration, the court or arbitrator as applicable shall: A. Consider any Sharia Advisory Council decision that has been published. B. Submit such a query for discussion to the Sharia Advisory Council. 2. The secretary must be consulted for any request for counsel or a judgment from the Sharia Advisory Council regarding this act or any other legislation. Next, Section 57 Central Bank of Malaysia Act 2009. The Islamic financial institution mentioned in Section 55, as well as the court or arbitrator mentioned in Section 56, must abide by any ruling made by the Sharia Advisory Council in response to a referral made under this section. 121(1), there will be to High Court with coordinate jurisdiction and status, namely A, one in the state of Malaya, known as the High Court in Malaya, with its chief registry at whatever place in the state of Malaya yang di-Pertuan Agong could decide. 1A, the court indicate in clauses do not have jurisdiction over any case that is handled by the Sharia court. 1B, the Yang di-Pertuan Agong will appoint location for the main registry of the Mahkamah Rayuan Court of Appeal, which will have the following jurisdiction. A, the power to decide appeal from High Court decision rendered by the register of or another officer of the court and appealable to a judge of the court in accordance with federal law, and any further sphere of influence that federal law may permit or recognize. That's all from me. Thank you.